Hello everyone. Welcome to another edition of the Webinar Talks. I'm Agni Chaudhary and today I will be hosting part 2 of the series on death benefit planning. This is the part where it starts to get messy. We will examine family situations in case laws where situations have turned sour. In hindsight, we will question some of those actions which might have prevented the mess from occurring. Again, I'd like to remind everyone that if you have any questions either during or at the end of the session, I'll share my contact details with you at the end of the webinar for you to email me. Here, the subject of the webinar primarily will be the discussion of the tools that enable us to achieve our death planning objectives. That is the trustee, the binding death benefit nomination, and reversionary pensions. I'll also be discussing some control aspects and cases where things have gone wrong. But before I proceed, I'll begin with a standard disclaimer. The material presented in this presentation is distributed as an information source only. This presentation does not give legal, business, accounting, taxation, financial planning, or other professional advice or services, and material in this presentation should not be relied upon as such. The information provided in this presentation is general in form. Formal legal, business, accounting, taxation, or financial planning advice should be sought in particular matters. Deed.com does not accept liability in respect of this information. Well, it is always going to be a difficult matter in determining the most appropriate beneficiary of the death benefit. It would mean the sizing up of a number of pros and cons because estate planning is essentially a family thing and has some broad guidelines. The question is, how do we conceive a custom planning blueprint based on our own family circumstances? For example, consider a daughter with 2 marriages, or maybe a son that lives overseas, or perhaps another son with a physical disability. Although it is common to make the estate the beneficiary, the decision should be thought out carefully. Some issues to keep in mind, especially when, for example, firstly, there is the possibility of estate challenge or estate insolvency. In the absence of a binding nomination or other restricted death benefit provision, trustee may use their discretion to wait until the time limits, which is a 6 or a 9-month period, for making an estate challenge have passed and then pay the superannuation to the estate to ensure that that risk is eliminated. This does not apply to New South Wales, by the way, where the concept of notional estate applies. There is nothing more alluring for a lawyer challenging the estate than that of an estate with SMSF money. Secondly, the will does not include appropriate clauses to manage the potential tax liabilities effectively. And finally, payment of the death benefit as a pension to the desired beneficiary. The SIS regulations permit the death benefit to be paid as a pension to the surviving spouse and in certain situations, as discussed before, to the children of the deceased. Where it is possible, it is generally desirable to pay a pension to the eligible recipient as the superannuation death benefit remains in the superannuation system and therefore continues to be concessionally taxed. Where a child is the desired recipient, this tax benefit needs to be weighed against the fact that the superannuation death benefit pension must be paid out of the superannuation system when the child turns 25, unless they are disabled. These issues obviously need to be considered in light of the overall planning considerations, and in some cases it may be appropriate to have the superannuation death benefit paid to the estate. However, it is critical that it is done after a full consideration of all the relevant facts. Whether death benefit decision can be made by the appropriate trustee after the death of the member, it is substantially easier. However, as discussed at a later stage, where a binding nomination is being prepared in anticipation of a member's death, the task is so much harder as the probability of certain events, say for example an estate challenge, has to be considered and factored into the decision-making process. The issue of who controls the superannuation fund is the most important one while planning for death. A number of legal cases will deal with this subject. The most important and iconic case is that of Katz versus Grossman. In Katz versus Grossman, a family relationship between a brother and a sister was jeopardized as a result of the sister, Linda, being admitted along with the father as a co-trustee on her mother's death to satisfy the SMSF trustee member rules. The father, Irwin Katz, had made a non-binding nomination in which he indicated that his death benefit was to be paid to both his son and daughter equally. After the father died, the sister used her trustee powers to appoint her husband Peter as co-trustee and together withdrew approximately 1.2 million of his death benefit. The court held that both Linda and Peter were validly appointed as trustees, and as a result, they were entitled to exercise the powers of the trustee. This included the discretionary power to pay the death benefit in accordance with the trustee and the SIS regulations. Following this case, a lot more attention was paid to binding nominations and who had the power to control the superannuation fund, where there was no binding nomination to prevent such abuses from occurring. Despite this, we still feel it is not enough that there is not enough thought being given to who controls the superannuation, where the superannuation death benefit decision is locked in either by way of a binding nomination, a reversionary pension, or a specific trust deed provision. This is most likely due to the complacency that results in the knowledge that the trustee has to comply with a pre-made decision. Here, the trustee's discretionary powers are very important. The trustee's discretion in relation to the payment of superannuation death benefits can be a very powerful tool in ensuring that the superannuation death benefit is dealt with appropriately. This is particularly the case in the SMSF environment, where you have control over the distribution and can use those benefits from superannuation payments very effectively with full knowledge of the facts at the time of making the decision. It is the general trust law provision that the discretionary powers of a trustee are not generally subject to review, and therefore there is very limited scope to challenge the exercise of that discretion. However, when such a discretionary power is exercised, the trustee must inform themselves of all the relevant matters regarding the exercise of the decision. Where it can be established that the trustee has not considered all relevant issues, it is possible for the original decision to be set aside. It is for this point that the preferred position by the trustee is not to provide reasons for the exercise of discretion. If the binding nomination is not valid, the reason supporting the payment of the death benefit to the claimant is flawed and can be the subject of a challenge. That being said, it is often not worth challenging these issues, as the court usually refers the decision back to the trustees to be redetermined. The recent Victorian Supreme Court case of Wooster versus Morris is a prime example of the potential issues that can arise where the trustee chooses not to comply with the trust deeds. In Wooster versus Morris, the Victorian Supreme Court was asked to consider the validity of a binding nomination prepared in respect of a self-managed superannuation fund that allegedly failed to comply with the terms of the fund deed. The facts of the case are as follows. Just before his death, Mr. Morris had executed a binding nomination in favor of his daughters from his first marriage, who were to receive all of his death benefits. Mr. Morris was survived by his second wife, being the only surviving member and trustee of the relevant fund. The second wife appointed her son of another relationship as co-trustee and member of the fund, and subsequently a corporate trustee was appointed. The fund deed required that a valid binding nomination must be delivered to the trustee. Now, it can only be assumed from the judgment that the second wife alleged that the binding nomination was never served on her and therefore was invalid. She and her son exercised the trustee's discretion and paid the death benefits to the second wife. The executors of Mr. Morris's estate, being their daughters, commenced legal proceedings seeking a declaration to validate the binding nomination and thereby ensure that the death benefit payout was as per the binding nomination. The judgment does not contain a detailed consideration of the reasoning why the binding nomination was valid. However, their daughters were successful. The courts also ordered that the daughter's costs be paid by the second wife and the new corporate trustee of the SMSF, and that the deceased superannuation benefit was not to be diminished by the court's order. This case is another reminder just how critical it is to deal with the control of the SMSF in all situations, including where the trustee's discretion is removed. Our clients will not thank us for the work we do if we have to go to court to enforce their right to receive the superannuation death benefit under a binding nomination, a reversionary pension, or maybe a specific trustee provision. Here I'd like to consider now the issues with the appointment of a replacement trustee. Here it is critical that you review the terms of the trust deed to determine how a replacement trustee is appointed in the event of the death of a trustee and member. This is because the deceased member will automatically cease to be a trustee on their death, and control of the SMSF will pass to the remaining individual trustees and the person who has the power to appoint new trustees. Where a member dies, Section 17A, subsection 3A of the SIS Act provides that the deceased legal personal representative, LPR, must be appointed as the trustee of the fund or a director of a corporate trustee within 6 months of the member's death in order to satisfy the basic conditions to remain an SMSF. If this is not done, the SMSF may cease to be a complying fund. And this is very important. Section 17A of the SIS Act does not automatically appoint the LPR as a trustee or a director of the corporate trustee of the SMSF. This is a common misconception. The importance of reviewing your SMSF trust deed to determine who has the power to appoint trustees was addressed in the case of Loppolo and Hesford versus Conti. Mrs. Conti and her second husband were members and individual trustees of an SMSF in this case. Mrs. Conti had made a number of death benefit nominations over the years in favor of her husband, but on the date of her death, there was not a valid binding death benefit nomination in place. Prior to her death, in her will, the deceased directed that her superannuation be paid to her children, and she expressly stated that her husband was not to receive any proceeds of the SMSF death benefit. At the time of her death, the SMSF trustee provided that unless there was a binding death benefit nomination, the trustee had absolute discretion as to how a death benefit was to be paid. Mrs. Conti's children from her first marriage were the executors of her estate. However, they were not appointed as trustee of the SMSF, since her husband was left as the sole trustee of the SMSF. The husband subsequently changed the trustee of the SMSF to a company of which he was a sole director and shareholder. Presumably, this was to ensure that the requirements of Section 17A of the SIS Act would continue to be complied with once the deceased death benefit was paid. After this was done, the husband proceeded to pay the deceased superannuation death benefit to himself and not to the deceased children. The deceased children challenged this decision on the following grounds. They argued that the deed required the deceased LPR to be appointed as trustee of the SMSF because the deed required the fund to remain an SMSF, and the trustees did not exercise their discretion in good faith. The second argument failed as the deceased husband had acted prudently, including taking advice on his obligations in relation to paying the death benefit. In relation to the first argument, the judge reviewed the requirements of Section 17A of the SIS Act and held that Section 17A subsection 3 allows for the appointment of the executor as a trustee of the fund, but does not in its terms require such an appointment. Therefore, in the absence of an express clause in the trust deed, the court found that the deceased husband was not required to appoint her LPR as a trustee, and therefore the husband's exercise of powers was valid. Hence, in order to pass control of the SMSF on the death of a member, the following issues need to be carefully considered. Number one, the choice of legal personal representative, as the intention will be for this person to become a co-trustee and assist in the death benefit decision, and the provisions in the trust deed for appointing trustees and legal personal representatives in particular. Here, it is worthwhile to re-emphasize the importance of the trust deed in such a situation. The basic rule of thumb is that your will, that is your state-based trustee laws or succession acts, has no power over your superannuation. Superannuation is governed by Commonwealth law, and regulated super have their own rules, which are the SIS Act and the Tax Act. If the client has left all their money in their super, the estate comprising of their children will have no power in the world unless they have an extremely strong binding nomination or an SMSF will. The trustees here will have the final say while making distributions to the estate. No matter how many lawyers you get involved, no power can force the money to the estate. This again brings us to the importance of a basic SMSF estate plan. Since the trust deed is actually the basis when it comes to paying a superannuation death benefit, it is essential that this is properly considered as part of the estate planning process. Often the trust deed is inflexible or imposes unnecessary requirements on the payment of a superannuation death benefit. That being said, most superannuation trust deeds still affords the trustee a wide discretion to determine how that benefits are paid, although that discretion is subject to the terms of any reversionary pension or a binding nomination. The provisions in SMSF trust deeds for appointing trustees are varied and sometimes thorny. For instance, some trust deed provisions require the determination of a majority of members for appointing trustees. This can be a source of problems when it comes to appointing the legal personal representative as a trustee, especially where the interests of the continuing trustee member and the LPR are not aligned, as in the case of Apollo versus Conti. Also, when reviewing or drafting your trustee appointment clauses, it is important that you are aware of the common drafting mistakes we see in SMSF trust deeds. These include the following. The trust deed does not give the legal personal representative the power to exercise the member's rights. This can be a particular problem where you have a two-member SMSF and the appointment clause requires a majority of members to approve the appointment. As no one is entitled to vote on the deceased member's behalf, it is not possible to appoint a new trustee. There is another major issue that is overlooked sometimes, and that is the timing gap between the dates of a member's death and when the replacement trustee is appointed. Unless this issue is properly addressed, there is no point drafting a trustee appointment clause that is going to work for your client's circumstances. This is because the surviving trustee can make the decision on whom to pay the superannuation death benefit before the replacement trustee is appointed in place of the deceased member. Other alternatives that you may wish to consider include the following. One, you could include appropriate language which makes it mandatory for the legal personal representative to be appointed as co-trustee of the SMSF. Two, the person who you want to ultimately control or co-control the SMSF could be added as a member and therefore a trustee of the SMSF at the time you are undertaking the estate planning, or else an enduring power of attorney is appointed. This will mean that there is no timing gap. And a three, in a blended family scenario with respective spouses wanting their SMSF death benefit proceeds to go to claimants from their previous marriages, it may be a good idea for the husband and wife to each create their own SMSFs with different corporate trustees. Coming to an SMSF with corporate trustees, Generally, the same control issues arise where the SMSF has a corporate trustee, except that the control of the deceased member shares, if they had any, in the corporate trustee needs to be examined, and power of appointing directors under the company constitution needs to be considered in addition to the trustee provisions. Passing control of the shares in a corporate trustee seems easy. However, it can often be more difficult than first thought. For example, leaving the shares to the intended recipient under the will is effective, except if the will is the subject of an estate challenge. However, even if the control of the deceased shares in the corporate trustee is adequately dealt with under the will, it is also necessary to consider the provisions in the Constitution for appointing directors. The majority of constitutions follow the Corporations Act replaceable rules that a majority of members eligible to vote at a general meeting is required to appoint a director. This position gives rise to the same issues as for individual trustees discussed above. Generally, the options discussed in relation to individual trustees can be used to overcome this problem if appropriately worded clauses are included in the company constitution. Where the SMSF member does not hold shares in the corporate trustee, an option is to include a specific clause in the company constitution that allows the legal personal representative of the member to appoint themselves as a director. Our trustee clauses uses approach 1, that is use of appropriate language which makes it mandatory for the legal personal representative to be appointed as co-trustee of the SMSF. With our trustees, appointment of a legal personal representative as trustee director of corporate trustee is mandatory for all the trustees through the use of words such as will and must in the clauses as contained in the trustees. A clause in the special purpose trustee constitution then ties the corporate trustee to act in accordance with the trustees and the SIS Act. Further, it is a requirement for all trustees, directors of corporate trustees to sign and lodge all the relevant paperwork with the appropriate authorities to facilitate the appointment. I thought we should also bring mental capacity into the discussion. Mental incapacity, though not an issue that arises because of a death, can be a huge problem for the operation of the SMSF. Where a member loses capacity, they are no longer capable of acting as a trustee or a director of a corporate trustee. There are two potential problems as a result. Firstly, if the person is not automatically removed as a trustee or a director of the corporate trustee, it may make a decision making impossible, particularly in two-member funds, and a vast majority of them are, as unanimous or requiring majority consents. And secondly, whether trustee or the Constitution provides that the person is automatically removed from their position in the event of incapacity, the SMSF may no longer continue to satisfy the basic requirements to be a complying superannuation fund. This is because Section 17A of the SIS Act requires every member to be either a trustee of the fund or a director of a corporate trustee. However, there is an exception to this rule which allows the member's legal personal representative to be appointed as a trustee or a director in place of the member. Section 17A, subsection 3B of the SIS Act. This has to be done within 6 months of the member ceasing to be a trustee or a director. Although you will need to check the terms of the trust deed carefully, as it may not permit the legal personal representative to be appointed as a trustee or a director, or a person to remain a member where they are not personally a trustee or director. A person will be a legal personal representative if they are a trustee of the member's estate, where they are under a legal disability, or they are the member's attorney appointed under an enduring power of attorney. It is a common misconception that the enduring power of attorney document needs to authorize the attorney to act as a trustee of the SMSF or give the attorney power to the member's financial affairs. However, this is not correct. Section 17A(3) of the SIS Act merely provides that the SMSF will remain complying where a person who is appointed as the member's attorney acts as trustee or director in place of the member. Therefore, this section will be satisfied where a person who is only appointed in relation to personal and health matters acts as a trustee or director in place of the member. If the member does not have a legal personal representative who can be appointed as a trustee or a director of the corporate trustee, the SMSF is at risk of being made non-compliant unless the member's benefits are rolled out, which will usually require assets to be sold to a retail or industry superannuation fund, or perhaps an APRA-approved trustee is appointed. Generally, both these options are not desirable. It is our view that it is non-negotiable for each person who is a member of an SMSF to have an enduring power of attorney in place to avoid these issues. One of the more commonly used nomination instruments is a binding death benefit nomination. A binding nomination allows a member to preordain the death benefit payment decision, therefore removing the ability of the trustee to determine who will receive the death benefit. We've spoken of this before. The trustee's discretion in relation to the payment of superannuation death benefits can be a very powerful tool in ensuring how the death benefits are dealt with. This is very much the case in the SMSF environment, where you have control over the distribution and can use the benefits from superannuation payments very effectively and with full knowledge of the facts at the time of making the decision. However, there have been instances where, due to a lack of certainty and wide flexibility created by the trustee's discretion, serious legal challenges have resulted. In such cases, it has been shown that a valid binding nomination would have solved the problem, such as the Katz versus Grossman or the Apollo versus Conti case. The source of the law is Section 59 of the SIS Act and Regulation 6.17a of the SIS Regulations, which allows the trustee of a superannuation fund to be structured such that a member can make a nomination which is absolutely binding on the trustee in relation to how the death benefit is to be paid. However, The provisions of the SIS Act and the SIS regulations regarding binding nominations only apply to retail and superannuation funds and not, I'm sorry, industry superannuation funds and not self-managed superannuation funds. As the legislative provisions have no bearing on the binding nomination process in SMSFs, the provisions of the trustee are the reference points in such a given situation. Therefore, in order to make a valid binding nomination, the process specified in the trustee must be followed precisely. Where this process is not followed precisely, the nominations will not be binding on the trustee and very likely, given the prevalence of estate litigation, become a subject matter of a legal challenge. As binding nominations in SMSFs are purely a trusteed concept, they are not subject to the maximum 3-year validity that applies to binding nominations for retail and industry superannuation funds. Therefore, unless there is a restriction in the trust SMSF trust deeds, it is possible to make a non-lapsing binding nomination in an SMSF. Here it is also possible to utilize your drafting skills and customize the binding nomination for an SMSF to cover myriad situations. Unlike in a majority of retail and industry superannuation funds, the trustee will accept cascading or conditional nominations. Most commonly, SMSF binding nominations even specify the form in which the death benefit is paid to the beneficiary. Here, complex situations, say for instance, prohibitions placed on the payment of a death benefit pension to ensure that a spendthrift son does not have all access to all their money. As discussed before, the trustee's discretion in relation to the payment of superannuation death benefits can be a very powerful tool, as it is the only estate planning decision that can essentially be made. However, there are many cases where this lack of certainty and a wide flexibility can be a serious problem. With a valid binding death benefit nomination, a member can curtail the powers of the trustee to otherwise distribute death benefits of that member to provide effective tax-saving situations. For example, pay the taxable component of the benefits to death benefit dependents and the tax-free components to non-dependents. Nevertheless, a valid binding nomination will be particularly important where, firstly, a blended family exists and a second marriages cause the member to want their superannuation benefits to go to children of a prior relationship. Secondly, it is not possible to control adequately the decision-making process where a death benefit is payable, especially in a retail or industry superannuation fund. Thirdly, there is no appropriate person to make the death benefit a decision. For example, a single member fund and the member has died. And finally, there is a risk of a dispute or a disagreement between the trustees and or executors following the death. For instance, where a widowed person or recently divorced person wants to ensure their death benefits are not paid to a deemed spouse. The Apollo versus Conti case is something that comes to mind at once. This list is by no means exhaustive, but provides examples of the more common situations where a binding nomination should be considered. A binding nomination, at least so far as they relate to a self-managed superannuation fund, and again because it is purely a trust concept, is subject to only the SIS Act, the Trust Law, and the Income Tax Act. And providing the fund deed and the binding nomination are appropriately worded, there is no reason why the nomination cannot direct specific assets to be paid in specie to perhaps a particular member, or given other direction to the trustee with respect to the payment of death benefits, or maybe even provide for the form of the payment of a death benefit, for example by way of pension on certain terms or by way of a lump sum. The biggest disadvantage of a binding nomination is the loss of flexibility that we've spoken about, in being able to have the benefit paid to the appropriate person based on the situation at the time. Again, this can be a very important in your circumstances change. Your binding nomination, unless it lapses, does not keep up with what is happening in your life. For example, what if the member has become incapacitated and thereby unable to amend a binding nomination? Adding further complexity to the situation, what if his spouse, the beneficiary, is also dead? This is why a binding nomination, as a matter of course, should not be recommended. A binding nomination can be very useful in the right circumstances, but the usefulness needs to be weighed against the loss of flexibility. Given these issues, there is no universal answer for death benefit planning. For many people, the flexibility inherent in superannuation is very important and useful, and for others, the ability to lock in the payment is vital. It is the job, therefore, of the advisor who recommends the binding nomination to carefully consider the probability of all situations and weigh up the pros and cons before making the decision. For instance, it is an absolute no to recommend the binding nomination in favor of the estate, where there is a risk of an estate challenge. It is a challenging solicitor's dream for the size of the estate to be increased by a significant superannuation death benefit payment. Also, it is not desirable for superannuation to be paid to the estate where there is a concern or a likelihood of the estate being insolvent but for the superannuation death benefit. Further, it is unlikely that the estate will be the default option where the superannuation death benefit is to be paid to a surviving spouse, as it is generally desirable to maintain the death benefit in the superannuation system by paying the death benefit as a pension. This again brings us back to the inflexibility issues of binding nominations, where binding nominations cannot be challenged. However, this does not mean that a binding nomination to the surviving spouse is the default option where they are the intended recipient. This is generally for the same reasons as spoken of before. Despite this, there are a number of advisors who will have every person who walks through the front door of their office sign up to a binding nomination to the surviving spouse without thinking through the consequences. Remedial actions such as revoking a binding nomination in favor of a spouse at high risk of litigation, for example, professionals, directors, business owners, surgeons, etc., will need to be taken into consideration in all cases. It is also necessary that careful consideration is given to the terms of the trust deed to ensure that the binding nomination has the intended outcome. However, there are a few other common mistakes which do not result in the binding nomination being outright invalid, but merely impact on the effectiveness of the binding nomination. First up, the accumulation versus pension question. Several trust deeds contain provisions allowing the payment of binding nomination benefits only through an accumulation account. Therefore, any amount in a pension account will possibly not be a subject of the binding nomination. However, this is not entirely clear, and there is an argument that the amounts in pension accounts are commuted and form part of the accumulation account following the death of a member in the absence of a reversionary beneficiary. Coming to the reversionary versus the binding nomination debate. Now, this is one of the more common debates in the superannuation industry at the moment, and it is whether a binding nomination takes precedence over a reversionary pension. A reversionary pension, by the way, is a pension that is being received by a member of a superannuation fund that expressly provides that the pension is to continue to another nominated person on the death of that member. This issue is once again governed by the terms of the trustee for the superannuation fund. Any good trustee should clearly specify the order of priority if there is both a binding nomination and a reversionary pension. Ordinarily, superannuation trustees provide that a reversionary pension takes precedence over a binding nomination. The reason behind this is that if the pension is taken to automatically continue under the reversionary pension rules, it never forms part of the death benefit to be dealt with by the binding nomination. However, this is not always the case. There are many trustees that provide that a binding nomination overrides any reversionary pension or are silent on which takes priority. The latter situation is particularly problematic as without clear guidance in the trust deed, there is the risk of having competing beneficiaries. At trust deed, we have covered specific situations during death when the member is either in accumulation or pension phase. For example, in the pension phase, if there is a valid binding nomination and a reversionary pension in place, the reversionary will take precedence over a valid binding death benefit nomination. Binding nominations in litigation. It is the responsibility of the advisor recommending the binding nomination to carefully consider the probability of all situations and weigh up all relevant facts before making a binding nomination in a particular form. But it is not funny how often they go wrong. For instance, it is an absolute disaster to recommend a binding nomination in favor of an estate where there is a risk of an estate challenge. It is the challenging solicitor's dream for the size of the estate to be increased by a significant superannuation death benefit payment. Also bearing in mind the likelihood of the estate being insolvent but for the superannuation death benefit is also worth a thought. In super versus out of super. Further, it is unlikely that the estate will be the default option where the superannuation death benefit is to be paid to a surviving spouse, as it is generally desirable from a tax perspective to maintain the death benefit in the superannuation system by paying the death benefit as a pension. Recall from our previous webinar The advantages of preserving the benefits within super are: the income from the assets supporting the pension is tax-free, and the pensions paid to dependents will be subject to income tax at marginal tax rates, less a 15% tax offset, and tax-free after the age of 60 years, unless the deceased was obviously over the age of 60 years, where it becomes tax-free. Moving on to areas of binding nomination challenges. Number one is the approved form. Considering the large amount of money held in superannuation which can be acquired through an estate challenge, super is increasingly becoming a key battleground for estate litigators. It is critical for a binding nomination to be made in accordance with the provisions of the trustee. This is where a vast majority of the challenges to a binding nomination are going to come from. Practitioners usually make the same common mistakes when implementing a binding nomination, and the following might be a snapshot of some areas of binding nomination challenges. There are a number of common trust deeds in circulation that require the binding nomination to be made in the approved form. Usually this requires the member to use the specific form set out in the schedule to the particular trust deed. Normally this is a fairly basic condition to satisfy, but it is surprising how many times it is not. Unfortunately, where the approved form is not used, it is irrelevant how well the alternative form is drafted, as it will not be binding on the trustee. As mentioned several times before, the provisions of the trust deed are of utmost importance. If they are not complied with, then the chance is lost. Unlike a will, there is no such thing as substantial compliance or testamentary intention here. Therefore, if the trust deed requires a certain form to be used, that is the only form in which a binding nomination can be made and be binding on the trustee. If you do not like it, amend the trust deed, not the form. Another common mistake we've noticed is that the binding nomination nominates a beneficiary that is either not an eligible recipient for the purposes of the SIS Act, we've covered this area before, or they are an eligible recipient for SIS purposes, but the trustee provisions, in particular the definitions, are inexplicably narrow. A common example that arises is where a former spouse is nominated in a binding nomination, and probably at a time where the two were indeed still happily married. The spouse then forgets about the existence of the binding nomination, and after his death, the binding nomination is brought to question since the former spouse is not a SIS dependent. We will cover exactly such a case a bit later in the discussion. Here it is critical that the terms of the trust deed, including every relevant definition, are carefully considered when making a binding nomination to ensure that it is valid. Some trust deed provisions require the trustee to acknowledge the binding nomination for it to be valid and binding on the trustee. Often this is an area of legal disputes, and parties are usually careless about due process in the execution of binding nominations when called upon to produce evidence that the trustee actually acknowledged the binding nomination. Most trustees are often caught off guard when called upon to produce adequate records to establish this at the time of payment of the death benefit. Also, this clause presents a problem where the trustee members have separated and one of the members wishes to make a new binding nomination. As the nomination has to be acknowledged by the trustee, you actually have to get the ex-spouse to consent to the new binding nomination for it to be valid. As you can all imagine, will this be possible? Finally, the compliance with the SIS Act and the SIS regulations. A common prevalent issue in trustees have been the use of non-specific terms such as the requirement to comply with the SIS Act or the SIS regulations. As discussed previously, Section 59, subsection 1A of the SIS Act only applies to retail superannuation funds and as such does not apply to SMSFs. Therefore, in our view, the trustee of the SMSF will not be bound by the binding nomination where the trustee requires the binding nomination to comply with or be binding under the SIS Act or the SIS regulations. This situation may be contrasted to a provision that does not require compliance with Section 59(1)(a) or Regulation 6.17a, but merely imports the technical requirements set out in these provisions into the trustees. This issue was the subject of the dispute in the case of Donovan versus Donovan, which highlights the importance of a form in a superannuation trustee and the implications of whether a superannuation death benefit nomination is binding on the trustee of a super fund. In this case, Mr. Donovan established a superannuation fund with a corporate trustee, of which Mr. Donovan was a member, and both he and Mrs. Donovan, his wife by a second marriage, were the directors of this corporate trustee. The trustee of the super fund required the trustee to be bound by a binding death benefit nomination, provided the statutory requirements were fulfilled. The trustee provided as follows. Statutory requirements were defined widely to include any law which must be satisfied by a superannuation fund in order to qualify for income tax concessions. Mr. Donovan signed a letter addressed to the corporate trustee advising that upon his death he wished to have his superannuation entitlements distributed to his legal personal representative for inclusion in his estate assets. On Mr. Donovan's death, his daughter by his first marriage, Linda, who was the beneficiary under the will, brought an application to seek the court's determination that Mr. Donovan's nomination was binding on the corporate trustee, of which Mrs. Donovan had control. The court found that a reference to statutory requirements for the purposes of the binding nomination provision was a reference to the formalities in a Regulation 6.78 subsection 6 of the SIS regulations. The formalities in the SIS regulations required the nomination to be in writing, witnessed by two persons, and contain a signed declaration from the witnesses, and so further held that Mr. Donovan's letter was not binding on the trustee. The letter written by the deceased to the trustee clearly did not comply with the requirement of Regulation 6.17a. As a result, the nomination was held to have been not binding on the trustee. It is by now a well-established fact that the superannuation death benefit does not automatically form part of the estate unless the trustee does decide in favor of the estate. If and when the superannuation death benefit does form part of the estate assets, they can then be dealt with in a manner as desired by the executor. Unlike super, there is no limitation on who can receive a super death benefit under a will. There are many reasons why a well-drafted will may need to consider how to deal with super within it, mainly because firstly, it has unintentionally formed part of the estate, although that was not the desired outcome. For example, a member in a single member fund dies without any dependents. Or perhaps the benefits may be paid to an unintended recipient. We all know the dire consequences of such an action from a tax perspective. Although this would not be the sole focus while formulating an estate plan, having an understanding of these is critical for any estate planner, as it can be used to maximize the estate for the beneficiaries. For instance, non-dependents need to pay tax on the taxable component of the benefit, which can sometimes be quite substantial. Finally, it may also be desirable for estate assets and super death benefits to form part of a testamentary trust. We will not delve too much into testamentary trusts, except that where superannuation is to form part of the estate, the primary reason is that it forms part of a testamentary trust. Secondly, where this happens, it is important that the terms of the testamentary trust properly deal with the implications of receiving superannuation death benefits. Most testamentary trusts have a wide range of beneficiaries to make it more tax effective. For instance, where there is a mix of tax law dependent and non-dependent beneficiaries, and the trustee has a wide discretion, it is unlikely that the tax benefit in Section 302(10) of the Income Tax Assessment Act 1997 will apply, and the estate will be taxed as if the death benefit is paid to a non-dependent. We will cover testamentary trusts in more detail in the final talk of the series. Let us now dissect a case scenario. This is a real life scenario that was presented to me by an accountant, and for want of being able to advise correctly, thought that it might be appropriate to discuss the possible options during the webinar. So here it is. Mel, aged 59, is a single member of the SMSF and a director of the corporate trustee. He dies leaving behind 1 million in his super, of which 75% is a taxable component of the benefit. The deceased Mel has a validly executed binding nomination which nominates 75% of his benefits to his son Alex, who is aged 24, and 25% to his former spouse Liz, who is aged 56. Now, what are the possible issues that we need to worry about? Obviously, the first question that comes to mind is the trust deed. Does the trust deed contain appropriate clauses to direct the trustee to pay the binding death benefit nomination? Moreover, is the binding death benefit nomination in the correct format and validly executed? Bear in mind that a binding death benefit nomination is solely a trust deed concept. Therefore, its implementation solely depends on the wording of the trust deed. Secondly, even if the trust deed and the binding nomination marry up in relation to the binding death benefit nomination payout, a death benefit payment to Alex, the son, may be made directly from the SMSF. However, Liz, who is the former spouse, although a tax dependent, is not a dependent for SIS purposes. This means that Liz might need to be paid indirectly through the estate unless she was an interdependent, although very unlikely. What is interesting to note here is that Liz is not a SIS dependent and is not eligible to be paid directly through the SMSF. But she is a tax dependent and can be paid through the estate, and the benefit will be tax-free in her hands. Alex, on the other hand, is a SIS dependent since he is a child of Mel and can be paid a lump sum benefit through an SMSF. But hold on a moment. He is not a tax dependent since he's a child over 18. So the tax-free component will then be taxable in his hands. Remarkable. This works out to 15% tax on 562,500 of which is the taxable component, and the tax actually works out to 84,375. This is indeed a large sum of money to pay to the authorities. Could this amount of tax have been avoided in this situation? Well, some alternatives to think about are Liz to be paid the lump sum benefit as she is a tax dependent, assuming she is Alex's mother and could be trusted upon to handle the sum of money. Was the binding nomination really necessary if two people related by blood were the only remaining beneficiaries, and control was therefore never an issue with this fund? Thirdly, if Alex was appointed as a trustee and legal person representative without the binding nomination, might he not have been able to achieve a better solution from a tax perspective? Fourthly, planning before Mel's death would certainly have helped bring down the taxable component and hence the taxable amounts. And finally, throw into the situation a second wife, stepchildren, spouses of children, and perhaps even grandchildren. And then you get a virtual soap opera with all the intrigues and deceits, which will keep the lawyers busy for a lifetime. For example, consider a second wife as co-trustee in Mel's SMSF. She might well have been able to invalidate the binding nomination on the pretext that it was payable to non-SIS dependents. This is the stuff of our third and final webinar of the series, where we'll explore strategies on death benefit planning. Again, we've come to the end of another webinar. Although this webinar does not address all the issues associated with superannuation death benefits, hopefully it provides a useful insight into the breadth of issues that must be considered and the most common mistakes committed in this area. If you've enjoyed these webinars, look forward to the final webinar of the series where we'll explore strategies around death benefit planning. We would also appreciate any valuable feedback or queries. which you can direct to agni at trustdeed.com.au. So goodbye and have a fabulous day ahead. Bye for now.